Welcome back, BADM 107 students. We are going to be completing the chapter 3 on contracts in this video. And it starts off on slide 102 with one of my one of my favorite topics. And that is standard form contracts. How many of you in the last week have entered into a standard form contract? Well, you're all sitting there thinking, I don't know, did I? If you drove your car and parked at a place where you had to pay for parking, or if you went and took a bus and you paid for your ticket on the bus using your student card, of course, but you paid for your card indirectly, or if you went on the ALRT line, then you did enter into a standard form contract. A standard form contract is a contract on a take it or leave it basis. And by that, what I mean is when you drive into a parking lot and you get to the machine and you put in your card and you get a ticket, you don't get to negotiate any terms. At Capilano University, although it's closed now, if you drove onto the campus and parked in the parking lot, you go to the machine, well, you're there for just one class in the morning of 3 hours. But they give you a ticket for the whole day. You don't get to say to the machine, hello machine, listen, I'm only here for 3 hours in the morning. Do I get a discounted price on my ticket? It's on a take it or leave it basis. And not only that, but there is a limit to their liability generally shown on the sign above where you pay for your ticket, and you don't get to negotiate those terms. So it's a contract on a take it or leave it basis. You get on a bus, you pay one price. You go 2 blocks, one price. You go right to the end of the line, same price. So you don't get to negotiate your ticket. Go to Mexico, go to a small town, you get on the bus. I've done this, and the bus driver says, 6 pesos. And you go, no, 4 pesos. No, 6, 4. Ah, sí, okay. And you pay 4 instead of 6 pesos. You can actually negotiate to a certain degree, depending on how far you're going or whether you're a foreigner and you don't know, or you're aware of the local price. But in Canada, no. In the United States, no. In England, no. We have all these standard form contracts where you do not get to negotiate the terms. Well, when are you bound to some of these exclusionary clauses that says the business isn't responsible for damage even if it's their negligence? We're going to look at a series of cases to try to figure that out. The first one is from 1977, I was going to say that can't be right. 1877 in the United Kingdom, and it is Parker versus the Southeastern Railway Company. Now, Parker went down to take the train, and trains are used very often in the United Kingdom because of the small size of the country. And so he went in to use the train, and he got there early. Oh dear. Okay. So he goes to he buys his ticket for the train. Then he goes to the check counter, and he says, "Hello, I'd like to check my bowler hat, my valise, my umbrella, and go and have a cup of tea because I'm early for the train." So he pays a little bit of money, and they give him a ticket, and he puts it in his pocket, and he goes away, and he has his cup of tea, and he comes back, and he says, "I'll have my stuff, please." And he gives the fellow the ticket. The fellow hands him his bowler hat and the umbrella. Parker says, "And my valise?" The guy behind the counter goes, "Oh, ain't got no valise here, mate." So they've either lost it somehow, it's been stolen, or they gave it away to somebody by accident. So Parker's really upset. Because the valise was worth £80. And of course, £80 in 1877 was a lot of money. So anyway, the fellow behind the counter says, "Oh, I'm sorry, sir, but in the back of the ticket, there's an exclusionary clause that says we're only responsible for up to £10. Parker doesn't like this, sues the railway. It goes to the Queen's Bench. And the Queen's Bench makes a decision that is not in Parker's favor, and so Parker appeals to the United Kingdom Court of Appeal. So obviously this is a matter of principle for Parker, because the cost of the appeal alone would probably outweigh the £80 value of the valise. So they get into the Court of Appeal, and the Court of Appeal has three options, and they still do. Our Court of Appeal has three options. They can find in favor of the appellant, which is Parker, or they can find in favor of the respondent, which is the railway company, or they can say, let's send it back for a retrial. Okay, they don't do that third option very often, but they do sometimes, and they did in this case, because the Court of Appeal said nobody at trial asked the right question which would allow us to make a decision either in favor of Parker or in favor of the railway. And that question set out the law. So I'm going to repeat it a few times. Well, actually, you can just back it up. Back up the video and listen to it a few times, so I don't have to repeat it. In class, I repeat it a few times because you have to know this for the exam, okay? The Court of Appeals said what was done at the time the contract came into existence to bring the onerous term or condition to the attention of the contracting party. Okay, well, what they mean is when Parker paid for the money and got his ticket, what did they do to bring that exclusionary clause to his attention? All right, so they say they didn't ask the right question, so we're sending it back for retrial. The matter did not go to retrial, and of course you don't know exactly what happened, but I suspect that the railway company said, we didn't do anything. All right, so on the basis of party and party costs, they would have to pay some of Parker's legal expenses for the trial, some of his legal expenses for the Court of Appeal, and then some of his legal expenses for the retrial. And at this point, they thought, okay, no, we didn't do anything, so we're just going to settle with him, and it never went to retrial. So that set the law. Now, this is a ticket case, okay? So we're going to look at a couple of other ticket cases, and then we're going to look at a situation where the person signs an agreement, and it has onerous terms and conditions. So the second case brings it a little more to date and brings it a little closer to home. It's the Brown versus the Toronto Auto Parks. What happened in this particular case is Brown drives into a place to park his car, gives some money to the ticket dispenser, and he gets a ticket, and then he drives in the building, he goes up about 3 levels, pulls into a parking spot, gets out of his car, looks at the wall, and there's an exclusionary clause. Toronto Auto Parks will not be responsible for damage caused to the motor vehicle or damage or loss to the contents, even if caused by our negligence. And Brown goes, I don't like that, but man, I'm late from a meeting, gotta go. So he thinks nothing's going to happen, and he goes away, and he comes back, and his car isn't damaged. It's totaled. Like, it was just totally destroyed. And if I've got my facts correct, and it really doesn't matter because this will just add some juice to the story anyway. Another fellow comes in later and has a sports car. Vroom, 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 vroom. And he gets out of the sports car and he tosses the keys to the attendant and says, "Park it, will you?" Because they, besides giving you a ticket and you park yourself, they do valet parking. Well, he flips the keys because he wants to demonstrate that even though this is an expensive sports car, he's so well-to-do that he just, really doesn't care too much about it. Anyway, the parking attendant goes, oh, wow, and he gets in the car and he goes, vroom, 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 and he goes, vroom, 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 right into Brown's car. So he causes a huge amount of damage. So Brown comes back and they go, "Hey, listen, our negligence, but there's a sign that says we're not responsible, so too bad." Brown sues, and it gets into court, and the judge applied the rule in Parker versus Southeastern Railway Company. Well, there was an exclusionary clause, and he did see it. The problem was, though, it wasn't brought to his attention when the contract came into existence. Okay, he drives in, he pays his money, he gets his ticket, the contract is in existence. About 5 minutes later, he finds out, oh, guess what? There's another clause that you didn't know about when you paid your money, and that is that we will not be responsible for damaging your car. So obviously the court in that situation said, no, that is totally inadequate. He had no advance notice of the terms and conditions, and therefore he's not responsible, and Toronto Auto Parks had to pay for the damage. Well, in Royal Bank versus Klassen, we bring it a little closer yet and a little more recent. We have a BC case, and it's 2013. Klassen, Mrs. Faw, got a Royal Bank charge card, and she gave it to Mr. Klassen to use, so she could get the airline points. Okay, so he uses it for a while and he gives it back to her, and away he goes. Apparently, the account never got paid by Mrs. Faw, and we don't know what happened to Mrs. Faw, but the bank then goes after Mr. Klassen because he was using the card. Because inside the agreement, it says that if a subsequent card user uses it, they'll be responsible for the payments. Klassen did not apply for the card. Only Mrs. Faw applied for the card. So he was not aware of this particular provision. On the back of the card, though, in very small type, and if anybody's seen the back of a charge card, the printing is so incredibly small, you practically need a magnifying glass to read it. It says, whoever uses the card is responsible, but he didn't know that. And so the question was, did he get notice that would bind him to the terms? And the bank actually, a representative of the bank filed an affidavit claiming that both Mrs. Faw and Mr. Klassen had filled out an application card for the card, and that he was a co-signer on it. And the judge said, let's see the application. Oh, well, we cannot find it. And then Mrs. Or the representative of the bank also tried to repair that and tried to say something different in another affidavit. And the judge said, considering the bank's sort of propensity for keeping copies of everything and get everything in writing and everything, that it was surprising and disturbing that they couldn't find this co-application agreement. And then she tried to say, well, the two of them came in together, and then she said, well, no, maybe she came in and he came in later. And eventually, the judge did not believe the veracity of the bank's statements. The bank also brought a long list of cases which said that a co-user of the card could be and should be liable. And the judge went through the process. If you read the case, because you can find it on CanLaw if you look, if you read the case, the judge said those are all distinguishable. Remember precedent, how one side brings a case and the judge can distinguish it and say it's not applicable. The judge said they're all distinguishable because in those situations the person filled out a co-application form or actually signed the card. Okay, so those are the ticket cases. The next slide, 104, deals with the situation where someone signs a card. And probably a lot of people here have rented a car or a truck. You go in and you give them your license, and they make you fill out a form and everything, and then they make you sign the form, and they usually make you initial a few places. Well, in Tilden versus Rent a Car was 1978. And Clendenning went in to rent a car. He had to go to another locale so that he could visit his prospective in-laws. If any of you were married, you know what it was like when you met your potential father and mother-in-law. It was a fairly stressful situation. Maybe not for you, but it was for me. I remember when I was dating Kathleen and I got invited to the Sunday dinner. And I went to the Sunday dinner, and all the relatives were there. They always had a big Sunday dinner. And there were so many of them that they should have wore uniforms with the names in the back and given me a program so I could keep them straight. It was a stressful evening, but fortunately I didn't drink at that point, so I didn't have any alcohol. Anyway, Kathleen's in the kitchen with her mother preparing the dinner. That's to show me that besides being absolutely gorgeous, she could cook. And she popped her head around the corner and she said, "Peter, do you like Brussels sprouts?" And I went, "Ooh," because I wasn't quite sure what Brussels sprouts were. I was a young man from the prairies. We have, meat, potatoes, corn, peas, and carrots. Everything else is suspect. Okay. So I said, no, thank you. No Brussels sprouts for me. Well, Kathleen's mother, Mabel, decided that she was going to set the relationship straight from the beginning. She was going to show who was in charge. So out come our plates. We're all sitting at the table, and I get this plate, and there's the roast beef, overdone because it's English cooking, and Yorkshire pudding smothered in gravy, and potatoes with lots of gravy on because I guess she figures I'm Irish, partly Irish anyway, so I thought that was great. And then there was some carrots. Well, I start eating, and it turns out that Mabel had hidden Brussels sprouts underneath my potatoes. "Young man, you are going to eat Brussels sprouts." That was the message. Well, at that point, what do you think I did? I'll just pause here for a moment to get you let you think. Well, a lot of people think, oh, well, you do the polite thing, you would eat them. Well, no, I didn't. What I did was I took my fork and I peeled back the potatoes, scooped up the Brussels sprouts, leaned across the table, and put the Brussels sprouts on Kathleen's plate. Years later, well, shortly thereafter, all the relatives sort of either, passed away or moved out of BC with the exception of Mabel. And then eventually all the relatives moved back and they started up the Sunday dinners again. And we went to a Sunday dinner, and by now Kathleen and I are married. But anyway, we got to the Sunday dinner, and Mabel had made roast beef, overdone, Yorkshire pudding with gravy, potatoes with gravy. I think this time it was corn and Brussels sprouts. Well, by this time, I had I was the sophisticated person you see before you now, and I decided that Brussels sprouts were good. So anyway, we're there, and everybody gets their plates, and Kathleen's sister says, "Oh, Mabel, remember when Peter came the very first time, and he didn't want Brussels sprouts, and you hid them under the potatoes?" And everybody went, "Ha, ha, ha, ha," because they all remembered. Mabel denied it. Okay, absolutely denied that this ever occurred. All right, so that's setting the scene of what Clendenning was up against. He's coming to meet his prospective in-laws. So he goes in to rent a car. They give him the form, and the clerk says, "Mr. Clendenning, would you like to pay an additional $5 and get the additional insurance?" Clendenning says, "I don't know. What does it do for me?" And the clerk says, "Well, it doesn't matter then whether if you're in an accident, it doesn't matter whether you're at fault or whether the other person is at fault, the insurance will cover it." Clendenning says, "Yeah, okay, sure." So he pays the extra $5 in the initials, takes his copy of the agreement, goes out, gets in the car, drives to the dinner, has a drink before dinner, and then sits down and has wine with the meal. Everything goes swimmingly. Everybody likes everybody. So he's much relieved when it's all over, and he gets in the car to drive back, and bam, he's in an accident. The police come to the scene, and they check to see if he has been drinking, and he has been drinking, but he is not under the influence of alcohol according to the criminal code. So he is not drunk driving. So he now has this police report, and he goes back to Tilden Rent-A-Car, and he goes in, he comes up to the clerk, and he says, "Well, I want to thank you very much for suggesting that I get the additional insurance." And the clerk says, "Why?" And he says, "Well, because here's the keys, and here's the bumper." I'm just kidding. But he says that he was in an accident. And the clerk says, "Oh, well, Mr. Clendenning, did you consume any alcohol during the contract period? Clendenning says, yes, I did, but the police came to the scene and they said I was not intoxicated. Clerk says, oh, I'm sorry, but it doesn't matter. On the back of the agreement, which you signed, it says if you consume any alcohol during the contract period, the insurance is void. You have to pay for everything. Clendenning says, no way, nobody told me that. And he walks out without paying, and Tilden Rent-A-Car sues him. Can you imagine flying to Hawaii for a 2-week vacation, renting a car, and then not being able to have one drink while you're on your vacation? I mean, that clause is just downright stupid and ludicrous. Anyway, they get into court, and the document is shown to Clendenning, and Clendenning admits that, yes, that's the contract, and yes, he did sign it. And the lawyer for Tilden Rent-A-Car says, and do you see what it says at the bottom? And he says, yes, it says see reverse side for terms and conditions. So they have it stamped as an exhibit, and they pass it to the judge, and the judge looks at it, puts on his glasses, and he says, oh yeah, right down here it says see reverse side for terms and conditions. Case dismissed, Tilden, you lose. And the lawyer goes, like, what happened here? Well, what happened was the judge decided that that little notice at the bottom of the page was not sufficient notice, particularly because one of the things that everyone advertises, hey, how quickly you can come in, fill out the forms and rent a car with us, you'll be out the door and no problem at all. And so he said it wasn't sufficient notice, and Clendenning did not have to pay for the damage done to the car. Okay, so that's pretty clear. Now, it seems to me that the simplest thing for Tilden Rent-A-Car to do would be to bring in a risk management practice, sort of an operations management practice, where they tell their clerk when they fill out the form and the person's signing it, all the clerk would have to do is say, and please be aware, Mr. Clendenning, that there are terms and conditions on the reverse side of which you should be aware. Now, I should have timed it. That probably took 2 seconds. So had the clerk said that, Clendenning would have been bound to the agreement. What Tilden decided to do was move the signature line, the see reverse side for terms and conditions up closer underneath the signature line. Whew, problem solved, right? No. In the other Tilden case, Tilden Rent-A-Car versus Chandra, which is from BC, Chandra signed the agreement. It was one of those ads, get in, get out quickly, we'll have you on the road in 10 minutes or you get the rental free or whatever. And he gets his car, and the same thing happened, and he refused to pay. And they got into court, and the judge said that is not adequate notice. Okay, so they lost again. And this is a large company with professional, lawyers either on retainer or an in-house counsel, and they didn't read the court case from Clendenning. They just, oh, well, here's the obvious easy thing for us to do, and they lost again. So I don't know what the forms are like now, but I do know that at one time I went in to rent a truck. And I'm there with 4 of my friends because we're going to move this huge couch. Why 4 of my friends? Well, 1 for each corner of the couch and me saying, careful, careful, careful. That's a joke. Anyway, I'm there with a few of my friends. I'm renting the truck. We get to the point where I'm signing it, and I looked right at the clerk, and I said, are there any owner's terms and conditions on the reverse side of which I should be aware? And the clerk goes, huh? What? No. There's a well-trained clerk. So these businesses could absolve themselves of a lot of problems if they just did some risk management. And you say, well, okay, so they say, notice the terms on the reverse side. How can you prove that in court? Well, you would call the clerk, and 9 out of 10 times it'll turn out to be a summer student that was hired for the summer, and if he gets on the stand, he goes, well, I don't know whether I told him or not. But if you have good operations management policies where you hire a good student and you give him good instructions and you supervise him, then the court will believe the student. So the student's on the stand, and the lawyer for the driver will say, "Hello, son," to emphasize for the judge just how young and irresponsible and immature this student is. And he'll say, do you remember telling Mr. Clendenning to look at the reverse side? Yes, sir, I do. Well, how can you be sure? You're busy, you're rushing, there's lots of people. Perhaps you forgot. No, sir, I didn't forget. Well, how can you be so sure that in this one occasion you didn't forget? And the summer student says, well, I was trained that this is one of the most important aspects of my job, and I practiced, and then for the longest time I was supervised, and as it turned out, I worked that summer, and then the following summer I was given a promotion because I was such a good employee. Yeah, but son, I think maybe you've forgotten this. At some point the judge is going to say, oh, back off, stop it. He obviously told Clendenning, okay? Telling somebody works. If you go skiing at Whistler, then you can certainly afford to buy a textbook for this course. It's incredibly expensive to go skiing at Whistler. I remember my wife and I went up there one time, BC, that's before children, and we went up to the booth, and it was snowing like mad and crazy, and I said, 2 ski tickets, please, and they told me, and I was aghast at how expensive it was. I asked the lady if she'd mind wearing a mask and holding a gun on me because I felt like I was being robbed. So she gave me the ticket, and away we go. Well, on the back of the ticket, there's a notice in very small print that says they're not liable for injuries, even if caused by their negligence. How many people read that? I certainly didn't until I became a lawyer. And so was there adequate notice? Most of the price of a ski ticket at Whistler goes into a fund to fight negligence claims. They could eliminate a huge number of those negligence claims just by having the lady in the booth say, please be aware that there's an exclusionary clause on the back of your ticket, and it's also on the sign above the booth. I don't have to look at the ticket. I don't have to look at the booth. I've been told. I ignore it at my own peril. That's all she'd have to say. And then I would have a hard time in court claiming that I had no notice of those terms. I've got a pretty good idea that would work because Whistler's so expensive that my wife and I decided we were going to go to Mount Washington on Vancouver Island, which in fact doesn't have as many runs, but it actually has better snow usually than Whistler, and it's far less expensive. So we went there for a 5-day ski package. And on the Saturday, we went up to get the ticket, right, the 5-day ticket. I give the lady the money. She tells me that there's an exclusionary clause on the back of the ticket, then it's on the booth, okay? So I've been told. 5 days, Monday through Friday, we're leaving Saturday morning, and there's a commotion on the hill. Well, we left because we're not looky-loos. Looky-loos are the people, you're driving down the highway and all of a sudden, you're going at 5 miles an hour because somebody's in the ditch and everybody's going, to see if there's any blood or gore, okay? We're not looky-loos. We went home, but I found out later that what had happened was a couple from England had come to the mountain. They'd bought a ski pass. They'd gone up the mountain. Now, at Mount Washington, you go up the main lift, and then you go to the right to go down the green slope, which is the easy one, or you go left and you immediately go down a black diamond one, which is like stepping off a cliff. They're so steep. You go straight over the back, and it's like about a 2,000-foot drop, okay? But they have big fences up, so that can't happen. Anyway, what had happened was this lady didn't know. She went up, she went to the left, and all of a sudden she's flying down this black diamond run, skis going like this, and her pole's out behind her, and wham! She hits the stanchion that holds up the chairlift. They sued the mountain because a doctor was skiing behind her and stopped and pronounced her dead right there on the scene. So the husband sues for causing wrongful death. Not murder. Okay, it's not murder. They didn't intend to. But causing wrongful death. And if you remember in the chapter on tort when we were talking about conversion, conversion covers taking something under color of right, and it also covers theft. But in order to be theft and actually be a crime, you have to have mens rea, which is the guilty mind, and actus reus, the guilty act. Well, those requirements are missing, so there's no crime here, but you can sue them for causing wrongful death. And when they were in court, it was pretty obvious from the judgment of the judge that the exclusionary clause on the back of the ticket would have prevented the mountain from liability because it had been brought to her attention. The only reason that the estate won was because of something that happened during the questioning. And the one fellow said, well, okay, somebody's going down that run and they're out of control. And you know the stanchions that carry the people up in the chairlift are in the middle of that run. You know it's dangerous. And they go, oh yeah, we know it's dangerous. And they say, well, what do you do about it? And they go, well, first of all, we clearly mark the runs that it's, an expert run. And secondly, we pile bales of hay up in front of the pole so that if they hit, it won't be as bad. And then we also put flags a little farther up the hill so that it gives a warning. And they said, well, what happened in this case? And they said, well, oh, no, and then the lawyer questioning them said, so the bales of hay, you do that at the beginning of the season? Yes. And how's Mount Washington doing this year, snow-wise? And he says, oh, it's a great year snow-wise. And we had, more snow than usual. And they said, yeah, okay, and did the snow go above the bale of hay? Oh, yeah, they were quite a bit above the bales of hay. And then the fellow on the stand went, uh-oh. And the next question was, how much would it cost to bring up a few more bales of hay? Well, right away, the negligence exclusion is not going to protect you because what you've done is you've been grossly negligent. Okay, and so that's how they managed to win the case for the estate. But the waiver would have worked. Okay. So the risk management policy is to look at what you're doing and make sure that the person is aware of the liability. Now, when you buy a season's pass at the mountain, you also sign a separate waiver with the application for the season's pass, and in there it's signed and generally under seal, should be under seal. And what you're doing is you're saying you acknowledge that there are risks on the hill. So I wanted to talk about the waivers of liability. One lawyer teaching at Capilano University says that waivers are not effective. Okay, I'm going to take extreme displeasure with that position because I've written a textbook that is for this course, and I also have a chapter in there. No, I don't have a chapter in there, but the woman that was writing the other half of the textbook did a chapter on waivers, and we didn't include it, but that chapter I did read it, and it's very clear that there's numerous cases where waivers work, and then there's numerous cases where they don't, and it's generally because they are not used in the right manner. Just like Tilden Rent-A-Car, they have a contract and they get people to sign, but they don't do it correctly. Okay, so waivers will work. Okay, so that's the cases on standard form contracts. Yeah, we brought it home to BC. Oh no, sorry. In BC, the Chandra was an Ontario case, and then or Clendenning was an Ontario case, and then in Chandra it was the BC case, so that the law is consistent across BC or Canada rather. All right, so now we're going to look at the capacity to contract. And we're only going to do a little bit of this, and then legality of contract you can read on your own. There will not be very much on the exam about legality at all. So slide 105 lists the people who are under an incapacity or some incapacity to contract. All right. So there's minors. These are people under the age of majority. These are not people that dig in the ground with a pick. Minors, juridical persons, which are corporations or societies, labor unions, bankrupt debtors, persons of unsound mind or befuddled by drink, or persons incapacitated by drug or drinks. And then the list goes on in the next slide to include enemy aliens and native people. And then on that second screen where it says historical footnote, married women, all right, I think we should put native people down there as well. These are people that were under a incapacity to contract in certain respects, but as far as our native people are concerned, our government has been working with them, and they're giving them, full rights, and they're giving them back land, or they're giving them money, or and so this incapacity to contract that they did have is really becoming less and less of an issue. They're in that category too. The native, married women are in there just because, and this is on slide 106. I'd like to mention here that we are in Western countries very critical of the way some Middle Eastern countries and certain other countries treat women. All right, and I only say this because we should be a little cautious about being a little, hoity-toity about it, a little, smug, because less than 125 years ago in Canada, we didn't treat women particularly well either. In the early 1800s, I was doing research for a textbook that I never got around to writing when I was in history, and I read advertisements in the Upper Canada Gazette, which said, "Have wife will trade for cattle." Okay, so if you had a wife, it was like having a farmhouse, having cattle, having a plow, having some horses. It was an asset. The wife was an asset. And you could actually sell your wife or trade her for cattle. And then you could write to England and they would send you another wife. Because there were a lot of women that were in desperate straits in England that were looking for a better life. Well, okay, so, that changed over time. And what happened was in the early 1900s, we have the House of Commons and the Senate, and the Prime Minister appoints people as senators. And the Prime Minister was considering appointing a woman, and it became apparent that the statute that allowed him to do so clearly stated that women were not considered to be persons. Okay, and so this became a political football, and in about 1923, I think it was, the matter went to the Supreme Court of Canada. And the Supreme Court of Canada looked at the law and said, clearly, with respect to this statute, women are not considered persons. That caused a huge furor in Canada. And eventually the politicians got involved and said, no, obviously women are persons, and so they made the necessary change to the law. Okay, so women are doing a lot better, but there were situations where an estate would be wound up when a man died and the woman would get nothing. And that happened often, but in Saskatchewan it finally went to court. What had happened was there was a man who was married and he had 3 sons. And his wife died, and eventually he met another woman. And the children were young. He was working the farm, and I don't know whether he fell in love with the woman or whether it was just convenience or whatever, but pretty soon she's living with them, and she's cooking the meals and cleaning the house and doing the laundry and taking care of the little veggie garden and taking care of the children. And that allows him to go out and expand his wealth working in the fields and buying more land and getting a bigger farm, because he didn't have to worry about the kids in the farmhouse and everything. Eventually the children are older, the 3 boys are older, and the farmer passes away, and the 3 boys said, get out. told the woman to leave. Okay. After all these years of her taking care of them, he said, get out, because the farmer wanted all, or the kids wanted all the land. And she wasn't married to him, and therefore she had no claim against the estate. So it went to the court in Saskatchewan, and the court held that the land, there was no trust agreement that was signed saying that she was entitled to a part of the estate. There was no will signed that was said she was entitled to a part of the estate. But they created something called a constructive trust. That obviously the only reason he was able to amass this wealth was because she was there, and so obviously some portion of that was supposed to go to her, and they allowed her a claim. All right, and then eventually we have situations where all the assets are owned by a husband, and then the husband decides that his blonde secretary looks better than the wife, and so he runs off with the wife, or the blonde secretary, and he has all the assets in his name and the wife has none, and so she's in this particular difficult position where she doesn't even have the money to go after the husband for her portion of the estate. So we pass laws like the Family Law Act in the province of British Columbia, which says it doesn't matter, the assets in a business, in a family are owned in someone's name, they're deemed to be owned 50-50 to protect females. And finally, we're at the point, I think, where with the exception of pay equity and the glass ceiling in businesses where men say, oh yeah, she can be promoted so high but no higher, things are a lot better. All right, so I think it's a little hard for us to turn around and say, hey, the way you're treating women in the Middle East is totally inappropriate. I'm not saying I don't. I agree that it's totally inappropriate. But I think we should also say that let the pressures of the world and of the women change that. And let's not, let's make sure that our criticism takes that into account. Okay, so enough said. That's a little bit on my soapbox. But let's come back to slide 105, where they list the people that are under incapacity contract. Minors. I'm going to come back and I'm going to talk about minors in detail, but I want to go through the rest of the list. Juridical persons, corporations. I talked about the Bank Act and how it was a federal statute. Well, if I decided I wanted to form a bank, and believe me, I'd like to, because they rape and pillage, and they're very good at it, and I'd rather be one of the rapers and pillagers than the rapee and the pillagee. So I'd like to form a bank. So I form a corporation under the BC Business Corporations Act, and I call it the Really Solid Bank of Lower Lonsdale in North Vancouver, and I begin taking deposits and making loans. Well, that will be ultra vires the powers of my corporation. Ultra vires means beyond the powers of, okay? And it relates to government passing legislation that is beyond the powers set out in the Constitution Act, and it also relates to someone doing things that are prohibited by statutes. It's beyond the powers of them to do that. So if you want to run a bank, you want to run an insurance company, you want to run a trust company, or a railroad or an airline, you have to incorporate under a federal statute. If you do not do so, then it will be ultra vires the powers of your corporation to run that business. Okay, that's the only restriction on corporations. Other than that, corporations are deemed to have all the powers and capacities of a natural person. Okay. All right, labor unions. Now here's a weird situation. You should really read the textbook on this point because it will clarify it a lot better than I can do in just a few minutes. Labor relations may or may not exist for the purposes of suing them. In Ontario, there was a situation where a business, the employees went on strike, and what you're allowed to do on strike is picket around the property saying, management unfair, one for all and all for one, fair wages. But that's all you can do. Pardon me, that's all you can do. And so in Ontario at that point, the business could hire scab labor. Scab labor is while your employees are on strike, you can actually hire other employees to do the work. This isn't as easy as it sounds because there's generally a long process in hiring. Then you have to train them, then you have to supervise them, and so it's not as easy as it sounds. But it is possible. And so this plant hired some scab labor, and their trucks were lined up to go in the gate. And the first truck, got there, and these guys are blocking the driveway. One for all, and all for one. And so he inches, vroom, and they back up a bit, vroom, and they start going, and they start hitting his truck. And then pretty soon, ooga, 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 they're banging the truck with it, and the crowd mentality takes over. And the next thing you know, they're bouncing the truck up and down like this. And the next thing you know, they push the truck over. And that isn't good enough, so they open the door and they pull out the driver and they start beating up the driver. And gosh, when he stops moving, they go to the next vehicle in line and they grab it and they turn it over and they start beating up the person. Well, the problem was there's a lady that was driving down and she turns the corner and there's a long line of vehicles, and so she's sort of in the line of vehicles thinking, oh gosh, what's going on? And then she watches the truck in front of her get turned over and they start beating up the guy, and then all of a sudden they come to her car and they flip her car over and they pull her out and they start beating her up. And anyway, after it was all over, she sued the union for battery and lost. Okay, and the Ontario court took the position that corporations exist. They have all the powers of a natural person because the statute says so. Nowhere in the Labor Relations Code does it say that unions exist. So she could not sue the union. She had to sue the people that were beating her up. Well, is that dumb or what? Because, there she is, an elderly lady, and she's been punched in the jaw. And what's your name? John Smith? Is that S-M-I or S-M-Y? There's no, and because she didn't know these people, there was no videotape or anything, she did not have any rights to sue. Well, labor relations is by province, by province, by province. Let's come out to BC. Out in BC, we had a similar, well, not a similar situation, we had a situation involving a union. There was a fellow by the name of Terrian. He was a truck driver. And but he wanted to be more than just a truck driver. So he decided he was going to start a business. And he managed to get a contract with the city of Vancouver that said, yes, we will contract with you. I think we need 18 trucks, but we do not contract with unions, businesses that are unionized. And he said, I'm not. And they said, okay. So he enters into this contract, and then he starts hiring other truck drivers. He's going to drive on trucks, so I think he needed 17 other. And he hires these people, and the Teamsters, who is the unions for truck drivers, turn up, and they go, hey, man, you got to unionize. No, sorry. I got to back up. They said they would deal with him and give him a contract, but he could not belong to a union. He could hire union people. Okay. But he just hired people and they were not unionized. Along comes the Teamsters and they say, hey man, your truck drivers have to be unionized. And he says, yeah, sure. Okay, go ahead. Unionize them. And they start sending up to 17 people. And then the Teamsters say, and you, Terrian, you have to join a union because you're going to drive a truck. And he said, no, I can't. I am the owner of the company, and yeah, I drive a truck, but big deal. If I join a union, we lose the contract. Hey man, you're driving a truck, you gotta join a union. They force him to unionize. The city of Vancouver cancels the contract, and they're all out of work. Okay, one for all and all for one, but we're all out of work. Hey, the Teamsters, don't care. Terrian, who lost the contract and lost his business, did. So he sues them. Now, the Teamsters is a pretty rough and tough union. Just ask Jimmy Hoffa if you can find him. He was the president of the Teamsters, and he did a little bit of money under the table into my own pocket routine and disappeared. Okay, and the suspicion is that he's in the cement at the bottom of a building in Chicago. Okay, Teamsters, pretty tough guys. It was never proven, so I'm out on a limb here even mentioning it. But they're a really strong union. Okay, drop that and just realize they're a very strong union. So suing them was, a pretty bold thing to do. They get into court, and the union goes, "Can't sue us. We don't exist. Look at the case in Ontario." And the judge says, "Okay, wait a second. You sign contracts on behalf of employees that are unionized. You have an office. You sign a lease in the name of the union. You rent photocopiers. You sign the agreements in the name of the union. And suddenly you're saying you can enter into contracts on which you say are enforceable, but hey, we don't exist." And the judge said you cannot have it both ways. And therefore, you do exist for the purposes of being sued, at least in this situation. Okay, this isn't a tort. Well, let's see, interference with this would be a tort. So in the province of British Columbia, you can sue a union, and I suppose a union could sue you. But in Ontario, and I keep checking to see if the law has changed, but so far it's the same. A union does not exist for the purpose of being sued. Now, unions do have the authority under the Labor Relations Code to sign contracts on behalf of people that belong to the union. And they say they exist for that purpose, but that's all it says. So, can you sue them for the tort because they interfered with his contractual arrangements, which is a tort, remembering that one. And therefore, BC's law is different than Ontario. All right, so there may or may not be under a restricted capacity to contract because they don't exist. All right, bankrupt debtors. You have a business, it fails, you can't meet your monetary payments, you declare bankruptcy. What happens in bankruptcy is all your assets then belong to the receiver. Okay, and then the receiver decides what you can retain. And they say now you can retain your car. If you drive a Toyota, you cannot go out and buy a Maserati because you get that way to keep the money. But obviously, if you drive a vehicle, you can keep the vehicle, you can keep your TV and things like that. But everything else goes to the receiver and is then sold, and the receipts divided up amongst your rightful creditors. During that period that you are in bankruptcy, you lose your capacity to contract for other than necessaries of life: food, clothing, lodging, transportation. Oh, you can buy a car. No, you cannot. Okay, transportation is cab or bus or ALRT. And there was a case that I was involved in where a bankrupt debtor cashed in an insurance policy because there was a cash surrender value, which was inappropriate because that insurance policy wasn't for his benefit, it was for his wife and children's benefit. Cashed in, got the money, used that as a down payment, and got a loan to buy a car. I managed to convince the judge that the car should be returned to the car dealership, that the down payment and all the principal and interest payments that had been made should be returned and paid into court. Okay, and that happened, and that money was then divided up amongst my client that I was representing and other debtors. The owner of the car dealership came to court and complained, and he said, like, how was I supposed to know that the guy was bankrupt? And the judge pointed out to him that there was a bankruptcy registry, and everyone that was in bankruptcy was in there, and if you lend money to a bankrupt debtor, you do so at your own peril. So we got the money. Now, persons of unsound mind, people that are mentally incapacitated, or people incapacitated by drugs or drink, and I just noticed on my slide that there's obviously and alcohol is missing. Oops, pardon me. So I'll have to amend that slide. But anyway, at this particular point in time, take it from me, it means unsound mind or drugs or drink. Does not happen often enough that I am even going to deal with it. Just it's obvious that if somebody comes in and they're falling down drunk and you sell them, a drink in your bar for $300, he might pay for it, but he'll be able to get his money back because he did not have the capacity to contract. And I'll just mention one case where, just to let you know that it does come up. And it was a waiver case. Remember waivers of liability? Well, in Ontario, there was a ski hill that was putting on a promotion, and they had, instead of skiing, they had tubes, the inner tubes, and people would ride down the inner tubes, and they had a contest promotion. And one fellow turned up and signed a waiver, but there was a lot of alcohol on the hill, and the promoters knew it. There were booths that Kokanee beer, not Kokanee, that's BC, but Labatt's Blue beer and whiskey and stuff, and people were sampling it all. And this person came up and signed the waiver, and he was smelling of alcohol. And then later, when he tried to get in the tube, he'd had more alcohol, and he was so drunk he fell off, and he was supposed to be disqualified from the contest, but he complained so much that they let him in the tube, and he went down, and he was badly injured, and he sued. And the Hill said, "Hey, wait, we got this waiver signed by him," and he admitted signing it. But the judge said, "Hey, you were under the influence of alcohol, and they knew it. Ergo, the contract is void." Okay. All right. Enemy aliens. These are not green people that come down from outer space, hold a ray gun on you, and say, "Lead me to your daycare." Usually that phrase is, "Take me to your leader," but we're so heavily taxed these days that it should now be changed to lead me to your taker, because so much money is being taken from us. That's a joke. Anyway, forget that. That's why I'm not a stand-up comedian. Anyway, enemy aliens are people that we are at war with. Okay, during the period of hostilities, contracts are suspended or become void because they have no capacity to contract. All right. Canada isn't at war with anyone. We are doing a police action through the United Nations in Afghanistan, but that's not. That doesn't mean we're at war with Afghanistan. Okay, we're just working with the UN. But the United States, for example, has enemy aliens, and if those people, like Iran, for example, I did have an Iranian businessman try to talk to me about how to get his product from Iran into the United States because there was an embargo against it, and his business wanted to enter into a contract with an American firm, and I wouldn't do it, and so he went elsewhere, I think. But anyway, that contract. If the product was delivered to the United States, the American company would not have to pay, and the Iranian company would not be able to sue on that contract because they don't have the capacity to do it. All right, so that's capacity to contract, with the exception of minors, and we're going to come back and deal with them. Slide 107 shows pictures of the famous five women in Canada who in 1929 challenged that law that said women were not persons, because the Prime Minister would not appoint that person to the Senate, but that person didn't make any claim. And so these 5 women took the challenge themselves and made a constitutional challenge, all right, that changed the law. That takes us to the slide 108. 108. And it deals with minors. A minor is a person who is under the age of majority. What's the age of majority? Well, in Washington State and a lot of American states, the age of majority is 21 years. In the province of British Columbia, it used to be, at common law, 21 years. But then the province decided that, well, hey, you can go to war and lose your life. And you don't have to be 21, so maybe we should make changes to this. And all the provinces have done that, and they did it through statutes, provincial statutes in their respective provinces. And there's no consistency, okay, but there is a rhythm to it, okay. In BC, you are an adult when you become 19, Alberta 18, Saskatchewan 19, Manitoba 18, Ontario 19, Quebec 18, the Atlantic provinces, who knows, who cares? Okay, I'm just being kidding. They have their own rules too. So in the province of British Columbia, you are now considered to be an adult when you reach the age of 19, and it's been like that for quite a while. I can remember when my sister turned 21. Well, my parents put on a big party for her. We were not well-to-do, but they really splurged. So she was allowed to ask 21 of her friends. She had a cake, of course, with 21 candles. She received a really nice necklace from Mom and Dad with 21 $1 bills stuck in it, just for fun. And I was thinking, 21, like who cares about 21? You know, you can vote when you're 18. You can, go to war when you're 18. You can drink when you're 19. Like, what's the significance of 21? Well, for my parents, that was the common law age in which you did become an adult. All right, but now you're an adult when you're 19. Okay, the statute that changed that in the province of British Columbia is called the Age of Majority Act. That statute and the next one on the slide are the ones that you have to know for examination purposes. So the Age of Majority Act sets our age limit at 19, and then the Infants Act says that the parents of a minor cannot waive the minor's rights even if they're under the age of majority. So I had a lot of fun with our local school here because my kids were always going on field trips, to science centers and to museums and things like that. And the school always got us to sign a waiver. Okay, the kids would sign. Well, that's totally ineffective because a waiver is a contract, and they don't have capacity to contract for non-necessaries of life. And so a trip to a science center is a non-necessary of life. You might be able to argue that it's educational, but not necessarily. Anyway, I would sign this, and I would say, okay, my kid's signature is not enforceable, and I'd sign, and then of course mine isn't worth anything either because the Infants Act says that I cannot waive my minor's child's right to sue. A case in the province of British Columbia where a young boy goes into a kung fu place, and he signs a waiver, and he's under the age of majority, and the parents signed the waiver under the age of majority, and then the child injured, and the parents sue, and the business says, hey, they signed a waiver, you signed a waiver, you can't sue us, and the court said, hey, in the Infants Act, kung fu lessons are not a necessary of life, and therefore the child is under 19 and has no capacity to contract, and the parents cannot waive the rights. Okay, so necessaries of life, they're listed on slide 108: food, clothing, lodging, medical attention, legal advice, and transportation, and there should be education on there too. Okay. Anyway, legal fees. Yeah, we make the rules, okay, so we're going to make sure that if we give advice to a minor, he has to pay us. Apart from that, you can see that there's, the things generally go to, necessaries, real necessaries. And there's problems with this because, for example, if the child goes into London Drugs and is under 19 but has their own bank account and buys $400 worth of CDs because they're going to have a really big party, They could actually buy the CDs, pay for it by way of a check, and then go back home, cancel the check, and they will not have to return the CDs, nor will they have to pay for them. Okay? The business enters into a contract with a minor at their own risk. Okay, so a minor comes in and they're going to buy a ski jacket. And you would think, oh, clothing. It's okay. I can accept a check from the child because the clothing is a necessary of life. The pitfall here is that it's a necessary of life unless the child already has an adequate supply of ski jackets. So let's say the kid's, a real, hot shot, and he has 6 ski jackets so that when he goes skiing, he never has to wear one twice. You go, oh, wait a minute, it's a week ski trip, so he needs 7. So he goes and he buys a 7th. He pays by check. The check is canceled. The business sues. This is a necessary of life. And he walks in with the other 6 on a rack. And he says, hey, I already own 6. So the 7th is not a necessary of life. Well, the problem for the business is you don't get to look in his closet before you make the deal. So businesses really have to decide here whether they are going to eliminate the risk by not dealing with a minor or by accepting the risk that most people are honest. All right? And for a ski hill, obviously they're going to accept the risk, because if they decided that they were not going to let people under the age of 19 ski, they would literally go bankrupt because so many kids ski, all right? So that's that. Then there's this thing called beneficial contracts of service, and necessaries and beneficial contracts of services would be good terms to put on Part A of the exam. Beneficial contract of service is just a contract of employment. Okay, so you're a minor, you run away from home because your lousy parents, are always making you do things to make you work. And then you find out in life that you actually, if you're going to rent a place and buy food, you have to work. Okay, so you get a job. You go in and you're presentable and you're nice, and you say to the employer, is it possible to get an advance on my salary because I have to pay my rent? And the employer says, oh, sure. And so he in effect, he's giving you a loan. So he does that, and then you think, hey, I'm going to quit, and I'm going to go and get a job somewhere else, and then I get to keep that cash. And so you do that. Well, you will get sued by the business successfully because the courts have decided that a good work ethic is very important in the upbringing of a child. And so they say that's a beneficial contract of service, and the child is bound by it. Okay. On the exam, there may be a person in the problem, and it says this person who was the age 18 signed this contract and paid a certain amount of money by check. And then the check bounces. What's the issue? Well, the issue isn't that the check bounced and that's a bad thing. No, the issue is that he was under the age majority, that the goods were non-necessaries of life, and therefore the child does not have to pay for them. Okay. The next topic is on slide 110, and it's legality of object. And right away you think, well, a hit contract or a contract to buy and sell drugs. Those are illegal contracts. Yes, they are, but we're not talking about that. We're talking about regular commerce. And there are times when you enter into a contract, you have a business and there's another business here, and you're competing against each other. And so you think, well, we're spending so much time and money in advertising and better return policies and things like that, that maybe we could get together with that business and we say, we'll serve this market and you serve that market, and then we won't be competing, and then we can make a bigger profit. Well, that sounds great, but that does not help the consumer. Okay, as a matter of fact, it's adverse to the position of the consumer, who will benefit by the competition. So that would be an illegal contract. That would be fall under a provision in the Competition Act called not a monopoly, but I can't remember what it is, when you try to control the markets, or pricing. You try to control pricing. That's against the law under the Competition Act. So those are illegal contracts, okay? And then there's some contracts that are just void. It means you tried to contract, but you just made a mistake, and they're void, okay? And one, for example, is that somebody comes to you and says they really need a job, and you say you cannot afford to hire them yet. And so they say, but I really need a job. I really need a job. I lost my other job because of the COVID-19. Not my fault. I've got a mortgage on the house. I've got a bank loan on my truck. My kids need braces. And so finally say, okay, look, I can afford to hire you if you pay your own EI, employment insurance, to the federal government, and you pay your own WCB, your workers' compensation payments. You do those payments, I'll hire you. And so the employee says, oh, yeah, sure, great. And so you're very careful. You write out a contract. And then out of all your employees, he's the one that's going to get injured. And WCB comes and they say, you haven't been paying WCB payments. And you go, no, we have an agreement and he's supposed to pay it himself. Well, there's a rule in certain statutes that you cannot contract out from under them. In other words, you cannot enter into a contract with somebody to not do what the statute says, and so that would be void. Okay, not illegal. You don't go. You don't get put in jail or fined under the quasi criminal statute. You may have to pay a small fine or pay interest for the payments that you've missed, but there's supposedly no stigma attached to it. So that's what we're talking about. Read the chapter. Because we're not going to get into that in a heavy way, except for the concept of restrictive covenants. One of the problems with the previous textbook was that they decided to make it sexier. They decided to put in some stuff that would be kind of really interesting to students and make them want to buy the textbook, which is pretty short-sighted, really. And so they put in things about gambling debts and stuff like that. So they had to take some stuff out, and they decided to reduce the section on restrictive covenants and just mention them. And I was asked to review the new textbook, and I and a lot of other instructors said, no way, nope, can't take that out of there. It's too important. It happens too much in business. And they relented, and they put it back in the restrictive covenant material. We've used the textbook for years, and then it got so expensive we finally dumped it. But this material is in my textbook. Okay, so restrictive covenant is a term of a contract which the courts presume to be prima facie void because it restricts competition. What does that mean? Well, let's use the example of a dentist. Okay, so I'm a dentist, and my nickname is Painless Pete because I'm almost virtually painless. I have a long list of patients, but I get tired of doing dentistry, getting up, getting in the office, rooting around in a person's mouth with all that saliva and scraping away, and the smell of decaying teeth and little bits of meat stuck in. Oh God, why am I doing this? So I decide that I've been successful long enough that I can sell my practice and retire. You come out of university, you come from a well-to-do family, so now you've got your dentistry degree, but you do not have any patients. So this is a match made in heaven. I'll sell you my practice. You pay me not for the value of my drills and chairs and desks and instruments, because that would be negligible. You pay me for my patients, right? So we have this contract, and you begin to work, and I go to Mexico, and I lie on a beach, and I drink cervezas, and I read Lee Child books. And, well, after a while, there's only so many Lee Child books. And so I start getting bored. And then I have to shift into the shade because too much sun's bad for your skin. You get cancer, right? And then, beer, well, okay, cervezas. I can still have cervezas. But I'm really bored. Along comes somebody that's on vacation too, and they put their blanket down in the sun and they lie back and they go, and I'm going, oh, because I want to look in their mouth, and oh boy, to get in the mouth and scrape and drill, and I just got to get back at it. So I come back to BC, Now, I know I sold you your practice, and my practice was located in North Vancouver, so there's no way that I'm actually going to open up and compete against you, all right? So I'm going to go to Richmond and open up, start from scratch. No, I'm not. I'm going to go open up right next door to you. I'm going to put up a big sign, and it's going to say, Painless Pete back in town. And the patient coming down to your office will, right. And they'll come back to me. What have you bought? You've paid a huge amount of money for my equipment. Not good. So, when you buy my business, you put in a restrictive covenant saying that I will not compete against you for a certain period of time in a certain area. Well, that restricts competition. Shouldn't that person be able to come to me if he doesn't want to use you? Yeah. So there is a restriction on competition, but it's a reasonable restriction. The law says if a contract has a clause which restricts competition, then it is prima facie void. Well, what does prima facie mean? It means prima, first, face. When you first look at this, it looks like it restricts competition. It should be void. What that means is that it's not just, it restricts competition, void. What it means is it's a rebuttable presumption. Now, it looks like it restricts competition, but you can rebut that presumption by coming to court and saying there is a valid business reason for having that clause in that contract. All right? And the valid reason, of course, is that you would never pay me for the value of my business if I could then turn around and compete against you. All right? So I work all my life. I've got this client base, and I cannot sell it, the value of my business, because of this problem. So I don't get what I want, and you don't get what you want. So obviously, the courts say, okay, you've rebutted the presumption. There is a valid reason why this clause should be enforceable. Then the courts say, all right, there's types of situations. There's when you buy and sell a business, when you hire an employee and you give them proprietary information, you don't want that employee to then take it and use it and compete against you. And then the third situation is where I talked about the two businesses that decide to carve up the market and reduce competition. And the courts will enforce buy-sell like that. They take a lot closer look when you restrict an employee, but they'll enforce those. And then in agreements between businesses, they take a very, very close look at those. So let's go through them. In slide 114, it tells you the approach to the courts. Okay. First step, they say it's prima facie void. Okay. Prima facie, it's a rebuttable presumption. So then you can try to rebut the presumption, but unless there's a public policy reason why. Okay. So there may be some situations where it's good for all of society that this clause is void. But let's not worry about that. Just be cognizant of it. Okay. Prima facie void. It will be held void if there's a public policy reason why it should be struck down. And then the third step is after they get by the public policy and after you have rebutted the presumption that it's void, you go to step 4. And step 4 is the clause is reasonable in the interests of the public as to time, area, and the nature of the business restricted. So, I sign a restrictive covenant as Painless Pete, so I will not compete against you for a period of 2 years in North Vancouver in general dentistry. Okay, that would be held reasonable. And there's in the lecture materials, there's actually a little head note of a dentistry case that shows this point. You should probably read that. 2 years. Well, even if I don't have fillings or chipped teeth or anything like that, I should visit the dentist twice a year. That's what they recommend. Okay, so in 2 years, I go to you 4 times. if I don't like you after 4 visits, I should be able to go back to Painless Pete. All right, so the 2-year period would be fine. Area, well, I've got clients in North Vancouver. Okay, I have a couple that come from West Vancouver, and one person comes all the way from Richmond. But generally all my patients are from North Vancouver. So you cannot restrict me from doing dentistry in metropolitan Vancouver. Because if I opened up an office in Richmond, very few people from North Vancouver are going to drive all that way to go to a dentist. Okay, and then the dentistry, well, I could become an orthodontist because I would become a supplier to you as a general dentist. Okay, so I'm not competing against with you, I'm a supplier. So that would be more and more and more reasonable. There was another point I wanted to make about all the way to Richmond. I can't remember. Except that, for example, my sister-in-law, who's passed away not too long ago, would drive all the way from Langley to West Vancouver to go to a dentist. I don't know why he managed to take out all her teeth and give her false teeth, but she thought he was the bee's knees. Most people don't. Okay. All right. So that's the basis of a restrictive covenant on the purchase and sale of a business. Restrictive covenant on the purchase or on an employee situation is, as I mentioned, if you hired an employee and train them and supervise them, and then they take the information that you've given them and turn around and go after your client base, your customers, that would be unfair. And so again, in an employment contract, you can put in a clause that says you cannot leave and compete against me within a certain period of time or contact my customers. Young lad graduated from the business program. He wanted to become a stockbroker. Apparently you take courses for a year and then you work with a stockbroker for a year and then you get your license. So he did his year, and then he gets hired by the best stockbroker in Vancouver, which at that time was a woman who was working with the name of a big firm. It'll come to me anyway. One of the big stock brokerage firms. And he was so excited because this woman was making $5 million a year and was one of the best in the business. Anyway, she asked him to sign a restrictive covenant. And he came in to see me. His name was Miles. And he came in to see me and he said, I'm really excited about the prospects of being trained by her. But it says here that I cannot practice cannot compete against her in BC for a period of 5 years. And I went, oh, Miles, sign it. And he went, well, what, are you crazy? He said, I can't wait 5 years to do what I want to do. I said, no, sign her and open up an office next door to her and begin competing against her. And he went, what? No. And I said, well, because that is too broad and too long a time. I said, that restrictive covenant will be held by the courts to be unenforceable. And he said, oh, really? And I said, yeah. I said, because in effect it would say, okay, Miles, you have to leave the province of British Columbia to work. But if he went to Alberta, he'd have to take the course there and work for somebody there for a year before he could work in Alberta. So I said it would be unenforceable. Well, Miles thought, okay, I want to work for her, and so I don't want to do something like that because it would be bad for your reputation. So he just went to her and he said, look, that clause, my lawyer says sign because it would be unenforceable. And she went, really? And he said, yeah. And he said, and he explained why. Too broad, all of BC, all her clients come from the Lower Mainland. Miles was from Kelowna. He wanted to go back to Kelowna and work, okay? And 5 years is way too long. And so she changed the clause, okay? She said, all right, if you go to Kelowna, then you cannot contact any of my existing clients, and you cannot operate in Vancouver for a period of 2 years. And he said, sure, fine. And they sign it, right? And then he comes to me and he says, I've got another problem. And I said, why is that? And he said, well, because I've just started, and my uncle from Kamloops, or Kelowna rather, called me and he said, "Hey, Miles, I hear you're a stockbroker. I want to buy some stock in a company." And Miles said, "That becomes her customer." But he wasn't going to her and then her saying, "Hey, do this deal." He was coming to me. And he said, that should be my client. And I said, "Well, then just go back to her and tell her that. She sounds like a reasonable person." And he said, "But then what do we do?" And I said, "Well, CM Oliver." I knew it would come to me. CM Oliver is the stock brokerage company. I said, what color of file folders do they use at CM Oliver?" And he said, "What?" I said, "What kind of file folders?" He said, "Well, it's sort of buff, that sort of like beigey color." And I said, "Okay, then you tell her that you'll go out and buy some orange file folders. And when your uncle calls you and says, 'Hey, Miles, heard you're a stockbroker,' he becomes your client. You put the deal sheet in an orange folder. Then when she instructs you what to do, she's acknowledging that that's your client. And when you leave, you go into the file room and you go orange file, orange file, orange file, orange file, and you take them with you." And so he went back to her and he said, "Oh, yeah, sure, Miles, no, that sounds great, but you don't have to worry about the orange file folder. We'll just, when you leave, we'll sit down and we'll go through the files and we'll decide whose client is whose." I said, "Don't do that, okay? Because right now, it's like you're getting married. When you're getting married, you're in love. Da, 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 da. Da, 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 da. What could possibly go wrong? You will be married until the day you die. All right? Well, lots can go wrong. There's lots of divorces. When you're in love and you're about to get married, that's when you sign the prenuptial marriage agreement. Okay? When you're getting divorced and you go to your spouse, you say, "Okay, now let's be reasonable and let's divvy up everything." That's when the arguments are going to happen, right? You're getting divorced because you're not getting along. You're unlikely to be able to decide amicably, how to divide everything up. So to have a separation agreement is a lot more contentious than to have a prenuptial agreement. So as far as Miles is concerned, to have a contractual arrangement to satisfy whose client they are at the beginning is a lot easier than arguing about it at the end. Okay, so you do it up front. All right, now the business to business. We already talked about the businesses that decide to carve up the market to reduce competition so they can make a bigger profit. Obviously, those are illegal and in restraint of trade under the Competition Act. Okay, but there are situations where a business can carve up the market. McDonald's, okay, McDonald's Canada gives you the franchise for McDonald's. They will tell you not only what part of the city to open up your business, probably the corner. Okay, this corner, you have yours there. And you go, no, I want to be over there because there's another McDonald's there that is really poorly run and I'll be able to put them out of business. McDonald's isn't going to want that. If enough franchises were fighting against the other franchises, their whole franchise system would collapse and thousands and thousands of people would be out of work. So obviously it's in the best interests of society, the public, to allow McDonald's to dictate where the franchises will be. Okay? And it really doesn't restrict competition, does it? Because, you can only, in the Sunshine Coast, we have a McDonald's in Sechelt, but we don't have one in Gibsons. If we had one here, let's go back to Sechelt. So you want to have two in Sechelt, right? Well, there's a Burger King, there's a Tim Hortons, there's a Wendy's. So there's lots of other fast food outlets. There's pizza places, there's Kentucky Fried Chicken, although I don't know why anybody eats that stuff. Anyway, there's lots of competition for fast food. And so the public isn't really inconvenienced all that much by not allowing McDonald's to control their areas. And that was the other point I wanted to make about the dentistry in North Vancouver. Okay, so Payless Pete cannot be in North Vancouver. You can. Well, if I don't, or I don't like it, there are a lot of other dentists. Okay, so by making me not be there for 2 years does not really adversely affect competition because there's lots of other dentists. All right, and you should shop around. I went to a dentist in North Vancouver, and he said, "Oh, you got some, filling in there that we should do something about. And all your other fillings are really old, and we should probably take them out and put new ones in." And I thought, no, thank you. And then I went to another dentist that I've been using for years and years and years, and I said, "All my other fillings are old. Should they be taken out and removed?" And he looked at me and he said, "Why?" Like, because you need to go on a vacation, and so you need more money. So you should really shop around. Competition is important. Okay, next topic. Slide 115, duress, economic duress, and undue influence. Duress is defined as coercion of the consent of free will of the party entering in the contract, and the pressure must be exercised in an unfair, excessive, and coercive manner. So, sign this contract or I will beat you up, or sign this contract or I will, make sure that your, knees don't operate, or something like that is obviously what they're talking about. Okay, duress, sort of threats of force. Obviously, that should allow you to set a contract aside if you were forced to sign one. And then there's something that's not quite the same, and that's economic duress, which is defined, and I'm going to read that to make sure I get it correct. The coercion must place the party to whom the pressure is directed in a position where he has no realistic alternative but to submit to it. So they're not threatening you with violence, but they're threatening to put you out of business. Okay, you need to sell my product. I will only give it to you if you sign that agreement. Okay, and you really don't have any choice. And you can't get the product anywhere else. And N95 respirators. Okay, there are people cannot buy those, and so there was a business that had one, and they said, "You pay us, I think it was like 10 times what they're worth, and we'll sell them to you." And our government stepped in and said that is unconscionable under the criminal code, but the party that signed that agreement could also claim that that was economic duress, and they could get their money back. And then the last one is undue influence, and this occurs where there's not a contract involved. Okay, so I say sign this contract, or I won't deal with you and you'll be out of business. That's economic duress. But undue influence is a situation where you go in and you say, "Hi, uncle, how you doing? Oh, you're sick. You're not feeling well. Yeah, I'm really bad. I need a will signed." And you go, "Okay, yeah, I'll help you with that. And by the way, uncle, I would really like to have your car." And the uncle doesn't want to give it to you, but he's sick and he doesn't have anyone else, and so you unduly influence someone to give you a benefit under an agreement like that. Pressure by one person depriving the other person of his or her free will, where the first person receives a benefit. I went to an elderly lady's house in North Vancouver one time because she wanted to have a will drafted and sign it, and she could not get out of the house, and I was one of those silly lawyers that did house calls. So anyway, I went to her house, and we were there, and we were talking about her bank account, the money, where does it go to, and the house goes to whom, and she had a lot of antique furniture, and she had the most gorgeous corner cabinet that fits like nicely into a corner, and had glass, and it was, and I said, "Wow, is that ever nice? That I really like that." And she said, "Oh, well, if you like it, in the will, put in a provision that you can have that." Well, she passes away, and her family says, "Whoa, wait a minute! The lawyer gets the corner antique cabinet that's worth $8,000. A will, he gets paid $300. That's and there would be a suspicion of undue influence. Okay." And so I said, no, thank you. I mean, I really like it, but no, that would be inappropriate, and I think it should stay in the family. And she was quite insistent, but I said no. Not that there was undue influence, but there would be a suspicion of it. And if she's dead, I have no way of proving that there was no undue influence. And then I would be, I'd not only have to give the cabinet back to the family, but I would be reprimanded by the Law Society. So that's how undue influence works. And I am just going to take a moment and see how we're doing time-wise. That's an hour and a half. You know, that's a long time to look at a video. And we have two topics left. We have contracts and the issue of jurisdiction, and then we have options. And so what I think is I will stop here so that you can look at this one video over an hour and a half period. You know, lectures are 3 hours long, so this is, you know, it would not be inappropriate for me to go longer. But I think from a manageable standpoint, I would rather you look at a number of videos. And so what we'll do is we'll stop here and we'll come back and we'll do the issue of jurisdiction in another video, and then we will do options, and then we'll be finished chapter 3. Thank you.